Welcome back to Pace Immigration, paceimmigration.com, talking crimmigration today with U.S. and Canadian immigration lawyer Michael O'Rourke. Michael, good to see you.
Hey, Sean, great to see you. It's been too long.
I know. We have to talk more often. Let's speed it up.
Definitely.
And we're going to speed it up today with some quick questions from the email inbox. We get a lot of these when it comes to crimmigration. We have here, if I have a pardon for a criminal offense, can I enter the USA? We get that a lot.
So my favorite answer is it depends. And here, it really depends on the crime that was committed and then was later pardoned, or using the current term in Canada, where your record was suspended. So in the case of a pardon or record suspension, the U.S. disregards that. It is only for domestic purposes here in Canada. Whether you're going to be admissible to the U.S. really depends on the type of crime that was committed.
All right, we'll move on to the next one. We have, if I have a conditional discharge for a criminal offense, can I enter the USA? First of all, what is a conditional discharge, and can they overcome it to enter the USA?
So very similar answer. It really depends on the crime committed. A conditional discharge is one of two discharges available to defendants in Canada. Conditional discharge means that the court has found guilt and then has imposed a sentence, maybe dealing with some probation, maybe some confinement time, maybe a fine. But the conditional discharge, in order to be effective and become a discharge, the conditions have to be met, and it stays on your record for 3 years. The other type of discharge in Canada is an absolute discharge, where the court still finds guilt, but does not impose a sentence. So with the finding of guilt, that can create an immigration consequence, and depending on the crime committed, may cause inadmissibility.
I noticed you said there, and I just wanted to clarify for people out there if they heard it and went, oh, good, it's been more than 3 years. Even after 3 years that it's removed from your record, that doesn't impact the immigration consequences.
No, it's there forever, Sean.
Okay. Next one. If I have a stay of prosecution for a criminal offense, can I enter the USA?
Similar, almost the same. A stay of prosecution means that either the Crown has decided to drop the charges, or it can't move forward for one reason or the other. If they enter or an application for a stay based on 579 of the Criminal Code, after a year, if they don't resume the prosecution, then the case dies. If a judge enters a judicial stay, say to protect charter or constitutional rights, case dies right there. Crown can't move forward and prosecute. But it really depends, again, on whether there was an admission to the facts of the crime, whether there was a plea entered for the crime. Say if you pled guilty, or maybe nolo contendere, there could be the remnants or the artifacts of that crime, and those facts that could then be used by CBP and the border officers in the U.S. to say, no, we feel that you've committed this crime. Even though it doesn't result in a conviction, an admission is enough to create legal jeopardy and inadmissibility in the U.S.
Okay. Moving on to the next we have here. If I have been acquitted of a crime, will I still have a problem entering the U.S.?
So acquittal is probably the best of all circumstances, because an acquittal goes to the ultimate guilt or innocence of the person. That's based in the facts. So if you go through trial and the judge or jury finds that you are not guilty of the conduct which has been charged, then a judgment of acquittal is entered, and you are scot-free in terms of criminal consequences, and there's no finding of guilt. So if in most cases, an acquittal is going to just pass under the radar, and you're not going to have any issues with the border guards. However, if certain crimes have been tried, and even though you haven't been charged, even if you haven't been convicted, say, for instance, drug crimes, if the border officer feels that you might have committed that crime, or there's like reasonable grounds to suspect, then they could still find you inadmissible.
Okay, and after all of this, Michael, with what we're talking about here, I think it's important that people, if they're even a little bit unsure, they should, and they have a record, they should give you a call, at least for a consult, and you can sort them out on what you think is the best action.
Exactly. We really have to understand what happened, like in great granular detail, to really get to an idea if a past criminal act or a past prosecution is really going to come back and haunt them when they try and come into the U.S.
Excellent. All right. Thanks for this, Michael. That's Michael. You can find Michael O'Rourke. You can find him at mo'rourke at pacelawfirm.com. Michael, we'll talk to you soon.
Sounds great, Sean. Take care.
Bye-bye.
Bye-bye.